Support for Central Florida Public Media comes from Embry-Riddle Aeronautical University's worldwide campus, where students can launch or accelerate careers in aerospace, business, engineering, or applied science. More at erau.edu/ww.
I'm Sharon Stone. This is Engage. Earlier this month, a U.S. Court of Appeals for the 11th Circuit cleared the way for Florida to enforce its Protection of Children Act that bans children from attending certain live performances, including some drag shows. The law passed and signed in 2023 prohibits restaurants and entertainment venues from allowing children to attend an adult live performance defined as including nudity, sexual conduct, sexual excitement, or specific sexual activities, lewd conduct, or the lewd exposure of prosthetic or imitation genitals or breasts. Violators can have their business licenses revoked, receive fines, or even jail time. While the bill's language does not explicitly identify live adult performances as drag shows, the law's sponsor, then state representative and current U.S. Congressman Randy Fine, said the law would, quote, protect our children by ending the gateway propaganda to this evil drag queen story time, end quote. The case, as ruled on by the 11th Circuit, was brought by restaurant chain Hamburger Mary's, specifically the chain's Orlando location. A large part of Hamburger Mary's branding involves daily drag shows that engage the diners, including a family-friendly show on weekends. A suit was filed against the state by Hamburger Mary's Orlando, who argued the law is too vague and its application would cause the restaurant to lose revenue. An injunction was applied, preventing the law's enforcement, but that was overturned by the same court that issued it. In a final effort to bring down the Protection of Children Act, Hamburger Mary's Orlando is appealing to the U.S. Supreme Court to overturn the law. Melissa Stewart is the attorney representing the restaurant in challenge, and while the Supreme Court hears less than 1% of the cases that request hearings, she is confident the Constitution does not support the law. She explained the state already has laws on the books to protect children from inappropriate performances.
Florida has long-standing laws that protect children from obscene performances. In fact, this statute copies and pastes pretty much exactly from those laws. And the existing obscenity laws that Florida has had and has been enforcing on the books for decades, they prevent children from sexually explicit performances. They prevent children from going to strip clubs. Pretty much every state in the country has laws just like that. And those are absolutely constitutional. What Florida did here was they copied and pasted those obscenity laws into a new statute, and then they added some undefined terms. They created a strict liability offense, and they specifically included language that targets drag in particular. And they did that because they are trying to expand the definition of what is quote unquote obscene for a child. And we don't have to speculate on what the legislature was trying to do here. The bill's sponsor was very clear that this law was intended to target drag story hour. There is nothing obscene about drag story hour. So this is not about sexually explicit performances. This is about the state of Florida wanting to define all drag as obscene and inappropriate for children. And the First Amendment absolutely prohibits that.
Who decides if a drag show is sexualized?
That question hits right at the issue at the heart of this statute, right? Because those decisions, the decisions about whether or not a drag show violates this law, those decisions are going to be made by cops, by prosecutors. Those are the people that are going to decide whether or not to arrest somebody, whether or not to strip a business of its licenses to operate, its liquor licenses, whether or not to put people in jail. This statute carries, heavy fines and potential jail time. So it's going to be police officers and prosecutors who are making that decision. And one of the things that the Constitution requires is that laws be clear enough so that citizens know exactly what is and is not prohibited, and law enforcement, like police officers and prosecutors, they also have a clear idea of what is and is not prohibited. Because if it's unclear, if it's vague, if it's hard to tell, it creates room for discriminatory enforcement. When you have a term, an undefined term like lewd conduct or lewd exposure of prosthetic breasts, those terms have no definition in Florida law. They have no definition in the statute. And so what one police officer thinks is obscene for a child might not be what another police officer thinks is obscene. Maybe one person thinks that all drag is inappropriate for children and should therefore be illegal. And so if a fully clothed drag queen, in a ball gown reading a storybook to children, one police officer might think that that violates the law, and another police officer might think that that's totally fine. And that's exactly the problem with this statute, is that there's no way for people in Florida to know whether or not they're violating this law. And so what happens is you have that is exactly what creates this chilling effect, because if people are not sure, they're just going to steer far clear of the law because they don't want to face jail time and fines.
What are your concerns as a civil rights attorney about this law and how it is applied, and maybe what other laws it may lead to?
Right. So the 11th Circuit's decision, if it's allowed to stand, changes the landscape of First Amendment protections and opens the door for states to pass all sorts of discriminatory restrictions on speech. If the state can say, hey, parents, you can't bring your child to a drag show, then the state can also say, hey, parents, you can't bring your child to an R-rated movie. You can't bring your child to that Broadway show that features drag queens. Or if the state can tell you what you can and cannot do in the privacy of your own home, then there's really no limitation. If the state can just say, well, this is to protect kids, and so it's fine for us to criminalize the speech we don't like, then where is the limitation on that? What stops the state of Florida from telling parents what movies their children can and cannot see, or what books their children can and cannot read?
What happens if the U.S. Supreme Court declines to hear the case?
If the U.S. Supreme Court declines to hear the case, then I think it's a pretty bleak outlook for First Amendment protections, especially regarding drag and trans people and gender nonconforming people, because this decision isn't just about this one statute. The 11th Circuit's decision sets a precedent for a whole portion of the country. And I think that it's likely that we will see other similar laws follow and be upheld. And that's the thing about infringing on civil rights. When the government infringes on the rights of its citizens, it doesn't start by infringing on the rights of the people kind of at the comfy center of society. It starts with the people who are most vulnerable. It starts with trans people and drag performers and queer people and people of color. But it doesn't ever stop there. That infringement always creeps in. And this law, even though it is intended to target drag performers, will not just affect drag performers. This will be felt by everyone in Florida, whether it's now or whether it's in 5 years or 10 years. This will have a lasting and devastating impact on free speech rights.
That was attorney Melissa Stewart representing Hamburger Mary's Orlando. Critics of family-focused drag performances argue drag culture is inherently sexualized and inappropriate for children. One of those critics is Matt Staver, founder and chairman of the Liberty Council, an Orlando-based nonprofit that promotes conservative values. Staver leans on a 53-year-old Supreme Court ruling that said obscenities are not protected by the First Amendment to argue that the enforcement of the Protection of Children Act does not violate free speech.
This particular law, the Protection of Children Act, actually applies to adult live performances when they are obscene. And there's a specific definition for obscenity, and that's from the Supreme Court decision in the Miller case. And it has 3 points. Number one, if the performance or the depiction is something that arouses the prurient interest, which basically focuses on sex. And secondly, if it is patently offensive to the community, particularly for the age of the children, and finally, if it lacks any scientific or literary value. If it falls in that category, then it is obscenity, and therefore there is no constitutional right to have children in the presence of obscenity. So not all drag performances are going to fall in the adult live performances category. If they, however, are focused on sexual acts or sexual depictions, then they would likely fall under the obscenity definition and be prohibited. And it's not just for these drag shows, it's for any adult live performance. So this could apply to, for example, a parade. There are different kinds of parades where you might have a so-called pride parade, but you also might have a so-called pride parade that has patently offensive, sexually explicit kinds of presentations. That also would fall under this Protection of Children Act.
So from my understanding, do you see a person in drag as obscene?
A person in drag alone is not obscene. That would not qualify for the Miller test from the Supreme Court. So, for example, if you had someone just dressed in drag and they're reading a book and the book is not obscene, but it's a general book that has no obscenity to it, that would not fall under the act. But if you have, like, for example, let's look at Naples Pride. Naples Pride is an organization in Naples, Florida, that wanted to have a pride parade or pride meeting in June in the children's park. Well, a couple of years before, when they did that, it was completely sexually provocative. They wore G-strings. They were doing all kinds of sexually provocative poses. I won't even describe some of the poses that they were doing. And they were inviting children to come up and put dollar bills into their garter belts. That is something that you would see, for example, in a topless bar or some other kind of sexually explicit performance. That's inappropriate for children. That kind of demonstration would become an adult live performance that is prohibited under this act.
Hamburger Mary's had arranged what they had called family-friendly programs that consenting parents could take their children to. So why is that problematic?
Well, the definition of Hamburger Mary's of what's family friendly may not be in compliance with the law. So Hamburger Marys can have performances or different presentations as long as they're not obscene, as long as they don't fall under the adult live performance category. They say they're confused about this definition, but they should not be, because this is not something new. Florida didn't invent obscenity. It's been something that the Supreme Court has ruled on for many, many years, and it's a well-known categorization of what is obscene. No one has a right to present to minors obscenity. It's unconstitutional to do so, and there's no constitutional right from a First Amendment perspective to present obscenity to minors. So that's really what this law focuses on. It's not a broad brush for every kind of performance. It's only for those adult live performances that have obscene presentations.
So if these events were being performed by women in the same costumes, you might feel the same about whether they are lewd or obscene performances. Is that correct?
It doesn't really matter what kind of exterior makeup or hairdo that they have or clothing that they have. What really is the issue is whether or not it's obscene. Are they performing something that primarily focuses on sexual acts or sexual activity, or their various body parts that are very sexually explicit? That's the real categorization. If that's the case, it doesn't matter whether they're men or women, whether they're dressed up or not dressed up. That's obscene, and that is, when it's done as an adult live performance, children are not permitted to be present of any age, and that's the holding of the Court of Appeals, and that's the intent behind the Protection of Children Act.
What would you say to someone who says this ruling is chilling to free speech?
They don't understand the idea of obscenity. There never has been a constitutional right to engage in obscenity or to present children with obscene material. That's never been protected by the First Amendment. That's not controversial, and there's a well-known definition of what obscenity is. So there is no chilling of free speech. There is no right in the first place to the First Amendment to expose children to obscenity.
If you had to explain to a restaurant owner or a parent who's not a lawyer what this ruling actually means, what would you tell them that they can and can't do?
Avoid sexually explicit presentations in the presence of minors. And obviously, people understand what that means when they see these presentations. There are different kinds of presentations, adult live performances, or even drag performances. Some are obscene, some are not. I think it's pretty common sense when you see one that is obscene. For example, the videos speak for themselves. As an example, with regards to the Naples Pride, now they weren't involved in this particular situation, but it's an example of one that would be prohibited. What they did in Naples a couple of years ago is patently offensive based upon obscenity rules, and they know it. It's not a secret, and there's no vagueness in terms of where you cross the line. It's pretty obvious when you present something that is so focused on sex in the presence of minors. That is what this law addresses.
Matt Staver is the founder and chairman of the Liberty Counsel. While the lawyers wait to see if the Supreme Court will hear this challenge, things are almost business as usual at Hamburger Mary's. The drag performances continue, only now for a strictly 18 and over audience. Zach Mitchell has been a drag artist at Hamburger Mary's for a year and a half, performing under the name Annie Daynow. For Mitchell, this job is a dream come true.
When I moved to Orlando, I got to go to Hamburger Mary's, and I remember being like, "Oh my God, this is it. This is the place." And that was always my number one dream, was to get to perform at Hamburger Mary's. And so the fact that I now get to do it as my job is spectacular. It's so special. But we have an incredible show called our Broadway Brunch, which is every Sunday. It is by far the biggest event we do every week. And it is a family-friendly, mostly musical theater based drag brunch. And we do big style production numbers every week. And then the queens do solo numbers. And like a look into a week we would do, like the other week, we'll open with the song from The Greatest Showman, which is all these big circus costumes. I have this beautiful like sequin pink dress. I'm wearing a beard, lip syncing This Is Me. And then for my solo number, I'll do like for example, like what I was just talking about, I'll do Mary Poppins. I have a beautiful Mary Poppins dress. I do a whole mix around the room. Everyone's singing along to Jolly Holiday. It's very fun. And then we'll close the show with Hairspray. And we'll go out there, do a huge mega mix of Hairspray, get the audience all up dancing. It is so special. It's so colorful. It's so fun. But my favorite thing about it is the family friendly portion of it. Unfortunately, Hamburger Mary's is 18 plus right now. Mary's has taken absolutely incredible care of all of its performers and has made sure to put them first in a safe environment. And it's so magnificent to get to see all these families and these kids and everything. This is their first time usually getting to experience drag. And from a kid's perspective, what is there not to love? It's big fun music that they usually know the words to. I mean, we'll do Disney nights all the time, and these kids show up in full costumes. They're lip syncing to every word with us. And we are wearing big, bright, sparkly costumes. Like, what is there not to love about it? And getting to see the reaction of people is just, it's priceless. It really is.
So when you hear your show described as something inappropriate for children, what is your reaction?
To be quite candid, it makes me very sad and very frustrated because drag is a very special thing. And drag, even as mainstream as it has gotten, it still is not this like worldwide mainstream thing. It's still a relatively smaller thing in this world. And it's something that a lot of us hold very dearly and very special. I love drag. I will be the first to tell you it is my hobby, it is my job, it is the thing I spend every day doing things for. And to have that be under attack makes me so sad because it's what I love to do and it's what I love to share with people. And here's what I will say, and any drag queen will tell you this. Not all drag is family friendly, and not all drag is supposed to be family friendly. Nightclub performances where we're out at midnight and 1 o'clock doing crazy fun dance numbers on the radio, whatever, those aren't for children. We don't want children there, and children don't go there. That's not for them. But things like story times, things like family friendly brunches, pride events, everything, those things get curated so that they can be for families. We're purposely choosing numbers that can be there for all ages. We're purposely wearing costumes that are appropriate, that don't reveal too much of your body, that are majority like full body covered. And seeing this mindset of fear get in the way of letting people share in this joy of drag is really sad. And I would implore people that if you've never gone to see a drag show that's meant for all ages, please do, because they are some of the most fun, magical things. And that's what it's all about at the end of the day. I'm not trying to test the waters when it comes to a family-friendly performance. I know what I need to do and I know what's appropriate, and I'm not going to test the water in that.
So an appeals court ruled this month Florida can enforce what it's called the Protection of Children Act.
Yes.
What impact has that law had on your performances? Have you had to make changes? Has it affected your bookings?
It has, yeah. I mean, and like I said, Hamburger Mary's has gone 18 plus now, which really only kind of affected our Broadway brunch because a lot of our other shows are, again, nighttime shows that typically families and children are not at. But yeah, our Broadway brunch is no longer allowed to have children at it. And that's really unfortunate and quite upsetting. And also, as a person, I am very passionate about younger education. I've taught children in the past, taught them in theater. It is getting to watch kids grow up and learn the arts and experience all these things for the first time is very special to me. And so something I like to do in drag is drag story times. I've done many all around Florida, and like unfortunately now I'm not really able to do them. Or if I am, it is me taking the risk of, oh, am I going to get in trouble with the law if I go and read books to children? Which sounds so crazy. Me wearing, again, probably a big sparkly princess dress, sitting down in a bookstore reading books to kids is something that could get me in trouble with the law. And that breaks my heart. And now that's a part of my drag that I'm not allowed to do anymore, which is one of my favorite things to do. And now it takes away some of that security in drag because now it's always this like surveillant thing of, okay, I got to make sure there are no children anywhere near me, can't post certain pictures, can't choose this, can't do that. Like, because I'm scared. I'm scared that this career that I love is going to be taken away from me, just to be honest.
You had mentioned that you would encourage anyone who hasn't been to a show to attend one. I'm wondering what you wish people who have never been to a drag show better understood about what you do.
I wish they would understand a few things. First of all, that what we're doing is not that serious. At the end of the day, we are people putting on wigs and big extravagant makeup and lip syncing to songs that are not ours. Like, at the end of the day, it's not that serious. What we're doing is fun. It's all about the love in the community. The queer community has been through so much in this world. And drag is just a part of that we get to use to celebrate our culture, celebrate our community, and to just have fun. It's so fun.
That was drag performer Zach Mitchell. The Supreme Court is expected to announce their new case docket in late September. A similar law was struck down in Texas this week. U.S. District Judge David Hittner said a law restricting drag shows in the Lone Star State violated the First Amendment rights of Texans, suggesting that those offended by drag shows, quote, just don't go. Engage is a production of Central Florida Public Media. Subscribe wherever you get your podcasts so you never miss an episode. Richard Copeland is our senior producer. I'm Sharon Stone. You can reach us anytime with questions, comments, or story ideas. Send an email to engage@cfpublic.org. Thanks for listening.